Good morning. I call the Senate Standing Committee on Judiciary together for our fifth meeting. We've got a number of bills here, and before members complain or fuss about the length of the agenda, just remember the chair gets lots of requests to hear lots of bills, and one day it might be your bill. So don't fuss about a long agenda. I get the bills and I hear them as fast as I can if I find them worthy of moving forward. And we're stuck with what we got. We've got to go a little bit out of order to accommodate our special friend here in the audience, our K-9, Representative Wesley, if you want to come on up. And while you're coming up, Chelsea, if you would call the roll. Thanks, Matt.
Senator Berg. Senator Carroll.
Here.
Senator Deneen. Senator Neal. Senator Schickel. Senator Stivers. Senator Storm.
Here.
Senator Turner.
Here.
Senator Wheeler.
Here.
Chairman Westerfield.
Here.
Seeing that we have a quorum, we're authorized to do business. Just a reminder to everybody, all presenters, in the olden days with a 2-hour meeting, this agenda would give you a little bit more breathing room. We don't have a lot of breathing room today. So please keep whatever testimony you prepared as short and as concise as possible. We want to let people ask questions, and you answer them, but we need to, whatever you thought you were going to talk, cut it in half a little bit today and just try to move things along. Representative, you have the floor.
Thank you, Mr. Chairman. Good morning to all of you in the committee. Thank you for having us. It's a pleasure being here with KSP and May. And so this bill's House Bill 115, all it does is enlarges the definition of this canine unit. And so we also have Fish and Wildlife in full support of this bill. I just want to mention that. But I'm going to go ahead and introduce our guests with us, and they can go ahead and explain what May does, and we appreciate your time. This is also Sergeant Lori Strong, and also the liaison. I forgot your name. I'm so sorry. Angela Parker. So we appreciate Angela and all of the work that she does. You can go ahead and speak.
Good morning. Thank you so much for accommodating our schedule this morning. I'm Angela Parker with Kentucky State Police Legislative Liaison. This bill simply adds the electronics device detection canines to assault on a service animal, and also adds a generic definition for police canines that are in service to law enforcement. This bill will ensure that these canines are protected if any harm comes to them while they are performing their jobs. At the moment, if any harm is done to these animals while they're doing their jobs, there's no avenue for accountability.
Motion on the bill.
Senator Berg. Senator Carroll.
Aye.
Senator Deneen. Senator Neal. Senator Schickel. Senator Stivers. Senator Storm. Senator Turner. Senator Wheeler. Chairman Westerfield.
All those in favor, please vote by saying aye.
Aye.
Those opposed?
No.
Okay. To turn on. Chelsea, would you please mark Senator Schickel as an aye?
Thank you.
Thank you. Bear with us. We want to make sure we're following the rules, so we're going to actually look up the rules. A novel approach, some might say. Didn't we used to have the books?
Some committees have, some groups have, but the rules themselves are adopted every session.
Mr. Chairman,
Yes, sir. Sorry.
while they're looking for the books, is it okay that Sergeant Strong would
Sure.
be able to
Sure.
go ahead and explain a little bit about what May does, please?
Absolutely. Where is May? I don't see May right now.
She's hiding under me.
May's the only one that matters to us.
So we have two actually, May, and we also have Cam, who couldn't make it today, but they're electronic detection canines, and we are a part of the Internet Crimes Against Children Task Force. So when we go to a residence executing search warrants for our investigations, we're looking for electronic devices. So these dogs, they not only help us find things that could have been hidden from us, they help us find things faster as well, even if they're not hidden.
Can I ask a dumb question?
Sure.
I'm curious how devices are differentiated, because it seems like a house would be just chock full of all kinds of electronic devices. You're looking for hard drives or something, I assume, or I don't know what you're looking for, but how is it distinct from a microwave?
So they detect it's a specific chemical called triphenylphosphine oxide, and it's part of the coating that they put on the motherboards for devices that have storage capacity. That keeps them from overheating. So it's that
Cool.
specific chemical that they're actually detecting.
All right. Yeah.
Good girl.
Yes, ma'am.
Yes.
So when your dog is in an environment like this where all of us have electronic devices, how does the animal react?
So they're kind of conditioned to be calm like this anyway, because they're actually they're career change dogs, which is a nice way to say they flunked out of service school. So their initial intention when they were raised from puppies was to be service animals. And when they don't complete that program, the man in Indiana, his name's Todd Jordan, he takes these dogs and makes them ESD canines. So that's also part of her job, is to be a comfort dog, and Cam as well. So when we go to scenes and there's children on scene and things, they can act in that capacity too.
If I can add, Mr. Chairman, there's only 2 of these dogs in the state of Kentucky. And so for their safety and their protection, that's why we was trying to bring the safety of these dogs under the definition or the KRS statute that's already in place.
All right, Representative Wesley, your bill is passed unanimously with favorable expression and shall be on consent.
Thank you.
Thank you. All right. Representative Banta, you want to come on up for House Bill 78? I thought I saw her. Am I missing her? Oh, there she is. No, that's Angela. She's not here? Just kidding. We'll come back to that. John, do you want to come up, Representative Hodgson, for House Bill 144? Hodgson, excuse me. An act relating to privacy. You have the floor, Representative.
Thank you, Mr. Chairman. I'm John Hodgson, State Representative from District 36.
Jeremy McQuarrie, Major, Kentucky Fish and Wildlife.
Rich Storm, Commissioner, Kentucky Fish and Wildlife.
Mr. Chairman, the core of House Bill 144 is to help stop the expanding trend of government electronic surveillance by requiring that surveillance devices can only be placed on private open land with consent or a warrant. Most people think that's already covered and prohibited by the Fourth Amendment, the prohibition against unreasonable search and seizure without a warrant. However, a 1924 Supreme Court decision created the so-called open fields doctrine, which has been used to justify warrantless high-tech surveillance on private land, contrary to the intent of the Fourth Amendment and, more importantly, Section 10 of the Kentucky Constitution.
Senator Byrd. Senator Carroll. Senator Deneen. Senator Neal. Senator Schickel. Senator Stivers. Senator Storm.
Aye.
Senator Turner, Senator Wheeler, Chairman Westerfield,
Aye. Got a motion and a second to put this on consent. All those in favor, please vote by saying aye. Aye. Those opposed? It shall be on consent. All right. Thank you, Representative.
Thank you, sir.
Gentlemen, thank you both for coming. I know it's abrupt to have remarks prepared and then just get cut off with a motion and a second, and that never gets, I never get used to that. But you passed, so. All right. Still don't see signs of Representative Banta. Oh, there you are. You want to come on up? House Bill 78. Thank you, Representative. Thank you, Chelsea. All right, House Bill 78, an act related to sex crimes. Representative, you have the floor. Welcome.
Thank you, and thank you for hearing this. Representative Kim Banta from District 63. This is a bill you've heard before. The Prosecutors Association wants it. They inadvertently left out aunt, uncle, and first cousins in the incest bill. It's already illegal to marry first cousins in Kentucky. This is just kind of getting everything together for prosecutors in case cases come to them. So.
We got a motion and a second from Senator Schickel and Wheeler, respectively. Any questions? Seeing none. Madam Secretary.
Senator Berg,
Okay, you're right. Yeah.
Senator Carroll, Senator Deneen, Senator Neal, Senator Schickel, Senator Stivers,
Aye.
Senator Storm,
Aye.
Senator Turner, Senator Wheeler, Chairman Westerfield.
Aye. Bill passes with favorable expression. What's the vote count? They've all been unanimous so far. That one was 9 to
Mr.
1.
Chair, there is a no vote
on this one. I was talking about the ones prior to that.
There were 2 9-0s and then
This one's 9 to 1. Bill passes with favorable expression.
Thank you very much. Senator Schickel, you're upside down.
Oh, thank you.
That's not going to fix anything.
That's an understatement.
I don't know who I owe for doing that, but it was worth every penny. I know we've got folks here. Senator Howell is here on behalf of Representative Flannery on House Bill 83. And I believe, Senator, you've got some folks with you. And I know Representative Dossett, my good friend, is here with some additional language that is included in the substitute. Is there a motion and a second on the substitute? Motion. Got a motion and a second. All those in favor of adopting the substitute, please vote by saying aye. Aye. Those opposed? The sub is before us. Senator, you have the floor.
Thank you, Mr. Chairman. This is House Bill 83, Jason Howell, 1st Senate District. As amended, it does a number of things. I'm going to turn it over and let everybody here introduce themselves and talk about their part of it.
Thank you, Mr.
Sure your mic is on and green light's lit.
Yes.
There you go.
Yes, thank you. I'm Danielle Wilson. I'm a past president of the Kentucky Land Title Association, and I'm also an underwriter with First American out of Louisville. House Bill 83 has 4 sections to it. The first section is regard to the statute of limitations on judgment liens. This actually passed in the House in 2020, 77-14, with Representative Fisher carrying that for us. This one essentially sets the statute of limitations from the date of recording to 10 years, while allowing active creditors to extend that statute of limitations another 5 years with a filing in the clerk's office. What this effectively does is clean up old liens and expedites real estate closings. The Realtors Associations and the Bankers Associations are in agreement with this bill. The second provision of 83 is agreed upon with the county clerks. Last year in 2022, Senate Bill 135 gave the county clerks a deadline for implementation of the electronic filing portal. This gives them an agreed upon 6-month extension to that deadline. Section 3 of House Bill 83 modifies the fiduciary and judicial closing statutes. And what this does is it changes the 389A statute, and instead of giving a 30-day appeal period, it allows the heirs and the families to waive that 30-day appeal period when they are in agreement. And what that does is expedite the real estate closings while still giving anybody who wants to appeal an opportunity. The fourth provision of House Bill 83 is the mechanics lien statute, and Representative Dossett's going to speak to that.
Yes, Representative Myron Dossett, 9th District. The committee sub that was added to this right here basically gives a layer of protection to a commercial property owner in the event that a tenant contracts for improvements without the property owner's knowledge.
We have a question from Senator Wheeler.
So, currently, I guess if you have a judgment, you can renew that. I guess it used to be 15 years now. I think it's 10. But if you, I guess, attempt to collect at year 9, you can renew it for another 10 years. Does this do away with that?
Actually, the statute currently says there's 15 years to collect.
15, okay, 15.
What this one does is within that first 10 years, you may go file a proceeding to collect by like a foreclosure.
Sure.
And at the end of the 10 years, you can also file a motion to renew your judgment lien for another 5. So anybody in active collections will still have the 15 years available to them.
Okay, but all right.
Divers.
Thank you, Mr. Chairman. Appreciate this bill because I don't know if people really understand how significant it is. But I want to check on something, Senator Howe, you and I talked about. If the parties in a probate matter, which is where there is a will or there is intestate succession to property, that if the parties agree that are the recipients under whatever track you go, the statute sets up that even the agreement by all recipients that you, and especially where time to sell is critical because of interest rates and things like that, a district court agreement would not allow you to sell the property until 30 days for the right of appeal has passed. You're getting rid of that portion. So my first question is, and then I want to ask another part that you can answer both at the same time, is how is that documented? Because is that sufficient by an agreed order? Because I had one of the underwriters require me to have an affidavit, not just an agreed order signed. You had to have a sworn and subscribed to affidavit that they wanted, and what is technically called a nunc-pro-tunc order, which was, some people don't get into that, but one, how is that effectuated? And then two, because I don't do title, I know that a lot of practitioners don't even realize that section's there. So if you actually got an agreed order and judges don't realize it, and they sell the property on day 15 and haven't allowed the right of appeal to pass, you now have a defect in your title. We talked about a statute of limitations to clear the title up. Is the statute of limitations issue taken up in this?
Yeah, is kind of a global answer. As to the first part, the order or the agreed order in this, that would allow the property to be sold at that
suffice.
point. Pardon? Yeah. Now, where you get into the affidavit part with underwriters, different underwriters have different ways of approaching with this. Danielle can talk more to that, obviously, than I can. But they're going to want some sort of additional work on that, and I think attorneys that deal in this space will as well, some. And changing that void to voidable means that if there is a challenge, you can come back and look at it. But it allows us to move. It allows us to move faster. And this this has some retroactivity language in it as well. Good. Because you're correct. So many people don't understand that you have to wait that 30 days. And some people do understand and just do it anyway. So we're cleaning up a blue million potential defects of title by doing this as well.
Void and voidable. That's a really good distinction, because some act, if it's unconstitutional, it is void ab initio, in my opinion. Then other things are voidable. So it happens on day 15. You're waiting for, and this is going to be pre this legislation. When does it become voidable?
Senator Stivers, when the current statute says void, I'm an underwriter with First American, and I see that in the chain. I automatically require, you're correct, it's a defect in title. It could be 20 years ago, and we have to go back and clean that up. If we change the wording to voidable, then it gives an option for the parties to become an agreement to waive that 30 days. And as an underwriter, I would be comfortable with an affidavit from all the heirs saying we're okay with this.
Okay.
That could happen anytime within the 30 days. And, I get this question probably daily that, we have the court order, the heirs want to sell this property tomorrow, and per statute, we cannot sell it with that word void in there. And that's what we're trying to clean up.
I'm good with that.
And from a practitioner standpoint, it's hard to find people when there is money to distribute to them. It's really hard to find 20 years later.
Right. I got it. All right. Thank you, Mr. Chairman.
Senator Storm.
Thank you, Mr. Chairman. I wanted to talk to you about the committee sub on page 10, beginning at lines 15.
I think I have the committee sub here.
Regarding landlords who may have a tenant who undertakes to renovate a piece of property.
This is you, Myron.
And if you don't mind, if you could just go through kind of that explanation there and the notice requirement to the landlord as opposed to.
What page was that?
I think it's on page 10 of the sub.
Should be section 4, 3A.
Section 4.
Right, I don't have the sub.
And I don't know. Let's see.
Senator Storm, what part are you referring to?
I think it's
Oh, thank you.
sub 3, beginning at line 15, that
Okay.
through the rest of the page. My understanding is that's when a leasee elects to engage in renovations of a landlord's piece of property, correct? And mechanics liens that would come into play.
Yes.
Is there notice required to the landlord of any liens being filed against the landlord's property in that provision?
With this right here, what we would do, the tenant would have to notify the contractor that it is stated in the lease that the property owner must give permission to be able to do any renovations.
Thank you.
Senator Deneen. Senator Berg.
Question, and my colleague to the left may have answered this, but in the past we've entertained legislation that was designed to address the fact that some of these properties in this state have multiple heirs, and to actually find out within 30 days who has an interest in this property may not be doable. So my questions, one, are notice. How do we notify people that they may have a right to something? And then second of all, how does this bill address that issue? Are those people after 30 days just out?
First of all, the notice part that you're talking about for heirs really takes place as part of the probate process on the front end. So everybody that we know about is in the game, and it's no easy undertaking sometimes to identify and locate all of these heirs. It's needle in a haystack sometimes. But once you work through that part in the probate process, then you can go in and move, and they'll already have notice. So it basically flips the notice portion to the beginning, because when you'd file a motion to sell the property and submit your order, that puts everybody on notice. So they've got time before a judge's order. It actually works better, in my opinion, because it focuses on giving preemptive rights rather than reactive rights after an order has been entered. And as far as after the 30 days, then yes, but that's the way it is now too. You've got 30 days post order to contest, and otherwise then the property can be sold. Otherwise you could never sell a piece of property with any degree of certainty out of a probate. And Danielle, if you have anything to add to that, please do.
I'm just going to say that is the point of title insurance as well, since the underwriter is taking that risk that there are missing heirs out there. That's actually part of the policy. So we take that risk upon every day. This one's actually better because, like you said, he gives us notice. We feel more comfortable with the probate being open and it going through the probate, which is obviously not a quick process. that they are getting the notice they need.
All right, thank you.
Seeing no further.
I want to know the committee to take notice of the very smooth, subtle plug for title insurance that my colleague here just made.
Owners policies.
Need a motion on a bill and a second as amended by the
Second.
sub. Motion from Senator Wheeler, second from Senator Storm. Seeing no further questions, Madam Secretary.
Senator Berg,
No.
Senator Carroll,
Aye.
Senator Deneen, Senator Neal,
Aye.
Senator Schickel, Senator Stivers, Senator Storm,
Aye.
Senator Turner, Senator Wheeler, Chairman Westerfield.
Aye. Bill passes, I believe, 10-1? 9-1, excuse me. Miscounted. 9-1 with favorable expression. Please pass our thanks to Representative Flannery.
We'll do it. Thank you, Mr. Chairman.
Thank you,
Members of the
Thank
committee.
you, Representative Dossett. Appreciate it. Good work. All right. Representative Bratcher, come on down. House Bill 207, an act relating to internal police communications. And I hope with the hearing of this bill that every police chief that knows me stops texting me, asking me to hear the bill.
I'm going to say no.
I'm glad to hear it. Go ahead. You have the floor, Representative.
Thank you, Chairman and committee. I guess about 8 months ago, the city of Louisville and the police department and their representation came and asked that this program and that's embedded in this bill, House Bill 207, be implemented down here. And upon investigation and whatnot, I found out that almost every police department in America is going to eventually be doing things like this. And I'll let the experts start explaining that.
Yes, my name is Sean Butler. I'm the executive director for the Kentucky Police Chiefs Association. And Mr. Chairman, I do apologize on behalf of the police chiefs and committee members. Thank
Listen,
you.
if everybody started to apologize and for all the advocacy blasts that they send everybody out to do, we wouldn't have time to hear the bill.
Yes,
so
sir.
not necessary.
Well,
Jump right on in.
As you can see, we feel this is extremely important. What this bill does, and I'm going to cut my stuff in half as you asked, is it essentially it gives us the opportunity to take a look at officers that may be having issues and get them help before it becomes an issue. It does not, if it's a use of force or something that should be investigated, it does not negate that. That would be different.
Move adoption.
Got a motion from Senator Neal and a second from Senator Turner, it sounds like. Thank you. Any questions, members? Yes, Senator Schickel.
Thank you, Mr. Chairman, and thank you, Chief and Representative, for bringing this forward. You know, these programs are already in existence in a lot of places, and but I just did want, I was reading over the bill before I came in, and I just wanted to make an observation. I obviously support the bill, but when I look at it, because as you know, Chief, police work can be pretty dicey.
Yes, sir.
And when I look at the exceptions of confidentiality that are in this bill, I think it's important that police officers, when they use these services, are aware of these exceptions, because at times things get pretty dicey. That's the only way I know how to put it. But I do support the bill. Thank you.
Yes, sir, and that was the reason they're there. We want the buy-in from the officers.
Any other questions? Seeing none. Madam Secretary, please call the roll.
Senator Berg,
Explain my no vote.
Yes, ma'am.
I think this is an excellent bill. I want to make sure that the police officers that work in my district understand this is in no way, shape, or form an intention to try to figure you out or put you at risk or put you in harm's way. This bill is designed so that you are able to maintain your privacy and hopefully get help before it becomes a real problem. I'm voting no because I want to keep this bill off of the consent calendar so that I can speak to it on the floor. Thank you.
Senator Carroll.
Aye.
Senator Deneen. Senator Neal. Senator Schickel.
Aye.
Senator Stivers. Senator Storm.
Aye.
Senator Turner. Senator Wheeler. Chairman Westerfield.
Aye. Bill passes with favorable expression on a 9-1 vote. Thank you.
Thank you, Mr. Chair.
Thank you, Mr. Chair, members.
Thank you all. I appreciate it.
With all the exceptions on confidentiality in that bill.
Representative Neighbors, welcome. Your bill's my favorite. House Bill 338, an act relating to jury qualification. Representative, you have the floor.
Thank you, Chairman. My name is Amy Neighbors, and I represent the 21st House District. House Bill 338 would allow Kentuckians aged 70 or older to opt out of jury duty. Under the current statute, these individuals must request to be excused from the jury pool, and those requests must be reviewed by a judge.
Got a motion from Senator Turner, second from Senator, who was that? Deneen, thank you. You got a question, Senator
Yes,
Neal?
please.
You mind if we go ahead and jump in the question?
Sure.
Senator, go ahead.
Thank you for bringing this. I just want to understand something. I feel two different ways about this. One is that the 70-year-olders, of course now I'm 39, but
Me too.
right, 70-year-olders are some of the most intelligent, experienced, calm, level-headed human beings walking the face of the earth. And you know, from my standpoint, it just the value that's given to the system, the judicial system in that particular regard, it sort of lessens the ability to have a concentration of that wisdom at the table. So that's what makes me a little bit shaky about that. Can you push back and bring comfort to my soul?
I will attempt to. Of course, this just allows an individual to choose to opt out or not, with every chance that they have to serve on a jury. You know, maybe the first time they get the notice, they're not feeling well based on whatever health condition that they're dealing with, and this would just allow them to exempt themselves for that particular jury call without requiring any statement from a physician. Next time they receive it, maybe they're feeling better that go around and could serve on that jury. So it just allows them the opportunity to exempt themselves without having to seek a medical statement from a physician.
Just one more quick one, Mr. Chairman.
Yes, sir.
So thank you for that. So is there any data or review in other jurisdictions where this has increased or decreased the participation of those at that age or greater?
I'll be completely honest with you, those are not numbers that I have at this time.
All right, thank you.
You're welcome.
Senator Berg, do you have a question still? Okay, thank you. Any other questions? Yes, Senator Schickel.
I'm conflicted about this too. In fact, I think I'm going to vote no. You know, they can already opt out. They just have to tell the judge, you know, why they're opting out. Judge excuse them all the time. I look at my friends in the public defender's office back here in the back. Prosecutors love jurors over 70 years old. And plus, I agree with the senator that the perspective of those folks we would hate to lose. At least the prosecutors would. And the other thing is, so many of them have the time to do it, and one. So I'm a little bit ambivalent about it. Thank you.
You're welcome.
Any other questions? Yeah, Senator Wheeler.
Yeah, I have some conflict too for the reasons stated, but I am going to vote for it because, you know, I mean, I think generally if somebody really doesn't want to be there really bad, that's generally not a good person to have on a jury. Sometimes you don't want somebody that wants to be there too bad as well. So I'm comfortable with this. I know initially some people said that, well, this is the rule in federal courts. I think it is in half of our courts in Kentucky. And Eastern Kentucky or Eastern District is not automatically excuse over 70s. But I'm more comfortable with it than I'm not, because I think it still provides an option for these people to serve. So I will be a yes.
Thank you. Senator Turner.
Thank you, Mr. Chairman. As a person who's 40, I appreciate this bill. Under the present rules, you've got to get the judge to excuse you, and you got to go through the process, fill out a piece of paper and all that. A lot of people that's 70 years old and older don't even need to have to come to court. If they really want to serve, they can serve. If they don't want to serve, you're not going to have a pretty good juror anyway. So I really appreciate this bill being. We're respecting the age of the people who become, at that time, really where they need to be able to opt out without having to go through a process and sometimes have to show up in court and get excused that way. So thank you for the bill.
Got a motion from Senator Stivers on the bill, second from Senator Deneen. Madam Secretary, please call the roll.
Senator Berg,
Explain my no vote, please.
Yes, ma'am.
I know that in the areas that I represent, at this point, we really have trouble getting jurors. And I know that many of my retired friends have actually started doing jury duty because they're able, they're eligible, and they can. Until we know what this is actually going to do to impact our potential jury pool, I'm hesitant to go ahead. So I apologize, but I'm voting no. Thank you.
Senator Carroll.
Aye.
Senator Deneen. Senator Neal. Senator Schickel.
No.
Senator Stivers.
Did you get Neal's yes vote?
I thought he said no. But. Senator Storm.
Mr. Chairman, explain my no vote.
Yes, sir.
I appreciate the work you've done on this bill. My concern is we have a jury of our peers, and if there's an elderly individual that's charged with a crime, I'd like to have a jury of their peers. If it's a young individual, I'd like to have a jury of their peers. I think that's what our Constitution's founded on. I also noticed that we have a Commonwealth attorney here in the room with us, and as the comments that Senator Schickel made, I saw several heads nod in the audience. I do appreciate your efforts, but again, in the Eastern District of Kentucky where I practice, every jury member can fill out a form and ask to be excused, and they provide their doctor's excuse or something. Judges typically do that, but it doesn't happen in every case because I think those individuals are important to the process. Thank you.
Senator Turner. Senator Wheeler. Chairman Westerfield.
Aye. Bill passes with favorable expression. I lost count. 7-3. Thank you, Matt. Thank you, Representative.
Thank you.
Good work. I appreciate it. All right. Representative Miles, come on down. House Bill 369. An act relating to expungement. You have the floor.
Thank you. I apologize. Suzanne Miles, State Representative of 7th District. Thank you, Mr. Chairman, and thank you, Committee, for hearing this bill today. 369 is an act on expungements, and it has just a few changes. It's a very short bill. The most important part of this bill is on the first page where it changes it from series to multiple. That's one of the most important things. We have several people that are trying to help get their records expunged so that they can move forward, and this does not change any of the standards on what was qualified, the time period that they have to wait to apply, or anything like that.
Representative, does it change the requirement that the judge has to approve it?
Does it? No, it does not.
I knew the answer to that. I wanted you to say the answer to that.
No, it does not.
All right, thank you.
It does not.
Got a motion from Senator Neal, second from Senator Wheeler. Senator Schickel's got a question.
Yeah, I was looking over this. Anytime as a juvenile, it always gets me. We've done so much with juveniles the last couple of sessions, and done so much with expungement the last couple of sessions. And you're right, Representative. This is a very minor change, but when you look at it, really, I could only find one word: multiple versus series. But you could make the argument that when you say a series of offenses, the average person would think that those were related, whereas multiple kind of opens it up to whatever. That's the way I interpret it. And so this is, at least the way I read it, an expansion at a time when we're really trying to go in the opposite direction in many areas and make juvenile records more accountable for multiple reasons. So I just wanted to make that point, Mr. Chairman.
I'd have been surprised if you hadn't. Any other questions or comments? Got a motion on the bill, which we've already got a motion and a second on the bill. Madam Secretary, please call the roll.
Senator Berg,
Aye.
Senator Carroll,
Aye.
Senator Deneen, Senator Neal, Senator Schickel, Senator Stivers, Senator Storm, Senator Turner, Senator Wheeler, Chairman Westerfield.
Aye, bill passes with favorable expression 8-1, if I'm not mistaken. Thank you, Representative.
Thank you, Mr. Chairman.
Good
Thank
work.
you, committee.
Appreciate it. All right. I was trying to get all the really heavy stuff out of the way first. House Bill 568, an act relating to the public defender system. Representative Nemus, glad to have you.
Thank you, Mr. Chairman. As my guests are coming up, I just want to thank you for letting me come late. My job is to make sure that your bills don't fail on the floor.
Is this 2014? What's going on here?
That's exactly. My job is to make sure your bills don't fail on the floor, and we're putting a bunch of Senate bills through now. So I'll be quick to get back over and make sure your bills continue to go through. So what this bill does, all right, I guess we need to introduce ourselves.
Please.
Jason Nemus, State Representative, 33rd Jefferson, Oldham, Shelby Counties.
Ed Monahan, former public advocate.
Bernie Lewis, former public advocate.
Gentlemen, good to both see you again. You have the floor.
Thank you, Mr. Chairman. So our public defenders are gems of our system. We really have a lot of respect for them. They do very important work under the supervision of Damon Preston today and Ed Monahan before, and Ernie Lewis before him, and at the local level in Louisville under Leo and Lil Smith and Dan Goyette before that. They're top-notch professionals across the Commonwealth that we're very proud of the work that they do across the Commonwealth. What this bill does is it would bring the last office that is not in the state system into the state system. About 15 years ago, as President Stivers knows very well, Fayette County system was brought into the state system. And the reason they're outside is because they existed before the statewide system. And so this is something that's been inevitable from the beginning, and the timing is just right at this moment. So we'll answer any questions.
Motion on the bill.
Before I thank you for that, Senator, but before we do that, I want to ask the sponsor whether or not he wants me to call the substitute.
Sir. Yes, please.
Okay, so members, we do have a committee substitute. It was distributed in your materials. We have a motion on the substitute
second
from Senator Storm and a second from Senator Wheeler. All those in favor of adopting the substitute, please vote by saying aye. Aye. Those opposed, the sub is before us.
Thank you. And the substitute just adds Section 7. That came from the newest senator from Louisville. She suggested this. And what it does, it says that during the interim, while we're studying the transition, there will be no employee that's terminated without cause. Of course.
Motion on the sub.
It's been adopted.
Okay. Or motion on the bill.
Thank you. As amended by the sub, got a motion from Senator Wheeler. Is there a second from Senator Storm? Thank you. Any other questions or comments? I don't want to. Yeah, Senator Neal.
Thank you, Mr. Chairman. Just a couple, if I may. I understand what you're doing, I believe, but what's the impact of this in terms of, as I understand it, as it's set up now, part of that money comes from Louisville, if you're talking about Louisville's offices, and part of it comes from the state.
Yes, Senator.
And this would take that operation and put it under the state operation, correct?
That's right, Senator.
Okay. So does this improve? I'm just trying to get the impact of this. Is just get some sense of that. Does this improve their circumstances, or has no impact upon their circumstances, or what can you share?
Let me ask the experts to answer that. I certainly have an answer, but I think Mr.
Well,
Lewis.
I want you to answer.
Okay, I will certainly.
Yeah.
It would improve. The benefits are better and the pay is better for state employees than they are at the local level. So that's one thing for the employees.
Okay.
But this is a statewide system that, if you talk to Ed, who's the most recent retired public defender, and Damon, who's in the audience, our public defender system is looked across the country as being a model. And that's one reason, because we're unified, but it's also because we've had really good programming from the very beginning. Louisville system is very good under Dan Goyette and now Leo Smith. What this would do is it would improve it. It would. Just like it did in Fayette County about 15 years ago. We'll be in the system, all unified system, which is a good thing. And so, with the day-to-day lives of the employees, though, I want to be clear, their lives really won't change much, other than they'll be getting the state resources behind them more than they do today. But they'll be still representing folks in divisions 1 through 13 in circuit court, and 1 through 17 in district court, and 1 through 10 in family court in Jefferson County. They won't be going to Perry County or anywhere else. Just like the folks from Perry County won't be coming to Louisville. They'll be their day-to-day lives will be not affected much on a day-to-day level. Although their jobs will, I think, improve, especially their conditions.
So, if I may, Mr. Chairman.
Briefly.
I can't do anything briefly.
You're burning the clock here.
In investigating this or looking at this, did you talk to the people in the existing system or the mayor's office, or who was involved in it? I'm just trying to figure this out because I've been getting calls.
Of course.
Yeah.
Well, thank you, Senator, for that question. Yeah. So I've been thinking about doing this for about 15 years. So I was the director of the administrative office of the courts when the Fayette County came into the system, and I didn't have a direct role, but I was involved tangentially with that because the courts are involved when that kind of a transition occurs. And so I talked with my friends. Ernie Lewis was the public advocate at the time, and then Mr. Monahan after that, knowing that it was inevitable that it was going to happen, but it just we waited for the right timing, which is now. So I've been thinking about it for a long time, talking to a lot of people there. Recently, over the summer, there was a committee hearing in Louisville for the budget committee, and both the Republicans and Democrats were very supportive of having the state take this over. In many ways, this is like the Department of Juvenile Justice situation, where Louisville was the only place that was paying for its own, which isn't fair, and also hurts the system, I think, and hurts the local office. In many ways, this is similar to that. So, okay, those are some questions. Who did I talk to? I talked to a lot of council persons, but I also talked to the local, some local public defenders and some folks on the board. So I've talked to a number. I did not talk to Leo Smith or Damon Preston about this in particular because I didn't want it to look like they're trying to take over anything. So I didn't meet with them, but I've met with a lot of local folks.
Thank you very much. I appreciate it.
All right, we're going to move along. We've got a motion and a second on the bill as amended by the substitute. I know. Please, Madam Secretary, call the roll.
Senator Berg.
Running out of time here.
Senator Carroll.
Aye.
Senator Deneen. Aye. Senator Neal.
If I can explain my pass, I'm going to pass it this time, but I want to talk with you. I'm going to get with you on it.
Yes, sir.
Change that position. Thank you.
Senator Schickel. Aye. Senator Stivers. Senator Storm.
Aye.
Senator Turner. Senator Wheeler. Chairman Westerfield.
Aye. Bill passes with favorable expression. Thank you, Representative.
Thank you, Mr. Chairman. Thank you,
Gentlemen, good
Senators.
to see you both.
Motion for consent.
It's not unanimous, but thank you. Representative Nick Wilson, come on down. House Bill 249. We've got the last two bills on the agenda here, folks, and I'm going to give them 10 minutes per bill because we got to get out of here. I know there are a lot of people that want to speak on 249. A couple of people want to speak on 262. Keep your remarks short because I'll entertain a motion whenever I get a motion, whether we're done or not with the questions and the testimony. So, Representative, you have the floor.
With that being said, I'm Nick Wilson, 82nd District, Whitley County. I'll let my guest introduce himself real quick.
My name is Ronnie Bowling. I'm the Commonwealth's attorney for the 34th Judicial Circuit.
And as you said, we don't have much time, so I'll try to get through a long discussion very quickly. I'm presenting Kimber's Law, which would add the murder of a child under the age of 12 to the list of aggravating circumstances we have in Kentucky. I want to say up front, this is not a vote that is a approval or disapproval of the death penalty. This is about giving the jury more sentencing options, giving the prosecutor more tools, victims more tools to seek justice, and allowing some of those options to include penalties that do not have the possibility of parole in it. And as you see on the slide here, A Class A felony is penalized 20 to 50 years or life with the possibility of parole. If an aggravating circumstance is present, then it's 20 to 50 years, life with the possibility of parole after 20 years, life with the possibility of parole after 25 years, life without parole, or death penalty. And those last three options are only added if the aggravating circumstance is there.
We got a motion on the bill. Is there a second? Second from Senator Carroll. Motion from Senator Schickel. I don't mean to cut you off. Here's what I'm going to do. We got a motion and a second on the bill. I'm going to let the folks that have something to say and want to speak against it, but I'm going to let you wrap it up.
Okay, I'll just add quickly. A lot of times when this issue is brought up, the conversation focuses solely on the defendant, and I would just like to refocus on the victims of these horrible crimes that we're speaking of today. I would like to add that I consider an amendment to be unfriendly because we have this list of 8 aggravating circumstances, and the murder of a child should be on there. If we have a list, I think it deserves to be there. And with that, I'll come back whenever called on by you, Mr. Chairman.
Thank you, Representative. I appreciate your flexibility, and I wanted to give you more time than I've got.
I very much appreciate it.
Scott, if you want to come on up, I want to give you a chance to speak. And then the next folks after Mr. West will be Ben Griffith and Jason Hall. Or all three of you can come up and take turns as you please.
Thank you. I'm Scott West with the Department of Public Advocacy. 20 years ago, I was the directing attorney in the Murray office, and we get our news from Paducah. You hear a lot of Illinois news. So I was there when Governor Ryan commuted everyone on death row because of 13 exonerations. And since that time, 20 years ago, there have been 7 more, 20 in a little over 20 years. Sometimes they say it's because of corruption in Cook County. You know, it can happen sometimes a bad investigation. It could be an inept, incompetent lawyer. Sometimes it's just where the evidence is conflicting. In 2009, I tried a case involving the death of a child. And this was a subdural hematoma case, sudden impact syndrome. There was a brain shear, and the Commonwealth's experts, the medical examiner's office, said that death had to have occurred between 4.5 and 5.5 hours of the trauma that child suffered. The focus then became who had the child at that time. It was my client. But I had an expert, one that subscribed to Dr. Jan Leisman, who recently died, who's put it at up to 8 hours, which if it's happened between 6 and 8 hours, it was the co-defendant who was charged only with abuse, not with murder. It was a battle of the experts, and I was lucky to have one. If there had been a death penalty in place, if I had not been able to get an expert, and I still believe my client's innocent to this day, but there was a compromise verdict. They convicted on complicity because I had an expert who was willing to say that there is a body of science out there that contradicts this. To this day, I think that he was innocent. But you have a lot of places where if there's an aggravator, it's going to be filed. And this is a highly emotional case. About a year after this case, I was at IHOP, and one of the jurors recognized me and came up and said, you know, we thought you did a good job. We thought we kind of believed your expert. We weren't sure, but something had to be done for that child. And it was a highly emotional, traumatic case. But if the death penalty had been involved, we don't know to this day, and we'll never know if my expert was right or if the Commonwealth's expert was right. My expert was the Commonwealth Attorney's chief medical examiner in years prior, and had he still been the chief medical examiner, this case might have taken a completely different turn. The other thing I want to say is we spent a lot of time in the interim talking about PFO, multiple meetings over the last 2 interims. You know, when we talk about bail, I'm always there. How many years have we talked about bail in the interim? It gets vetted in front of a joint Judiciary committee. We get, you know, you hear more than a 2-minute drill from Scott West on something like that. This is the death penalty. It's our highest penalty. It's much more than PFO. We got to get this right. Please don't rush this through. Please, let's have some interim talk about this. The issue won't go away. It'll be there. Thank you.
Thank you, Scott. I appreciate that. And Scott, I want to mention you shared that story in an email with me, but I don't know if it went to all the committee members. Can I share that?
Most certainly.
Thank you. Jason or Mr. Griffith?
My name is Ben Griffith. I'm a member of a murder victim family group that speaks against the death penalty. I can assure you that families struggle with the issue of death penalty. We've discovered our objections to the death penalty not by intellectual exercise, but by the fire of a spiritual and moral struggle. And many of us urge you to see the alternative of life without parole as a preferred option for society and for family survivors. What's been come in more increasingly clear is that in the states that don't allow the death penalty and instead use the sentence of life without parole, that family survivors have a better quality of life. With life without parole, we put the murderer in prison, and then it's really over in a matter of a couple years. With the death penalty, it's decades of reliving. So I just urge you to support the amendment to replace the death penalty, remove it, and use life without parole as that ultimate penalty.
Thank you.
Thank you.
Thank you, Mr. Chairman. I'm Jason Hall with the Catholic Conference of Kentucky, and our objection is the same as Mr. Griffiths. We certainly agree with the sponsor that this offense deserves to be on any list of serious crimes. It's certainly a horrendous offense. But any expansion of the death penalty is simply not justified given the state of our death penalty system. 190 exonerations since 1973. And this is a government program that ends people's lives. And we can't take that kind of chance. We should not be expanding the death penalty at this point. We should be talking about rolling it back. And so for that reason, we do oppose the bill as it stands. But would certainly encourage you at the very least, if we would prefer, I think, to talk about this more, but if there is a desire to move forward, there is an amendment to remove the death penalty and still allow for life without parole or life without parole for 25 years. So thank you.
Thank you, gentlemen. I appreciate it. We've got a motion and a second on the bill. Representative, you're welcome to come back up.
Can I allow my guest to speak?
Yes. Yes.
And I'll just add quickly, I did think it would be prudent to study how the death penalty is used. And under the current statute we have with this, that was passed in 2012 with aggravating circumstances and mitigating circumstances and all the things the jury must look at, the death penalty has been given as a sentence one time since then. It's been given 3 times, or there's been only 3 executions since 1960. One of them was a man who asked to be executed. So if you actually look at the numbers, in practical life, the death penalty is not being used. However, there are children being murdered. And that's why I brought Mr. Bowling with me to discuss some cases that we've seen as prosecutors.
Thank you, Mr. Chairman. Ladies and gentlemen of the committee, I'll be brief. You've heard anecdotal story about what happens in a child homicide prosecution from my colleague in DPA. I would like to also tell you a story that I endured and why this law is called Kimber's Law. And a lot of times, sudden impact death syndrome, those are not crimes that are alleged under the intentional portion of the murder statute. A lot of those are shaken baby cases where wanton murder is at play, and that wouldn't encompass this bill. This is the intentional murder of a child. Kimber Collins was a beautiful 2-year-old girl that lived in the 34th Judicial Circuit that was beaten to death over the course of 3 hours. There were more bruises on her body than skin. And she died a terrible death at the hand of her mother's boyfriend. When she arrived at the hospital, she was dead. Her mother had to make the decision to unplug her from life support 3 days later, which is a choice no parent should have to see. I saw that child myself. I pray you never have to. So under the circumstances of that case, I chose to charge Michael Cody Huff, the offender in that case, with intentional murder, because I believed after the medical examiner identified 44 separate injuries to this 2-year-old defenseless little girl that he did it no other way than intentional. And that bill would be, he would be charged with an aggravating circumstance if this bill were law. So I believe it's an important bill. It's not something you're going to see in the shaken baby range or the battle of experts. This is an intentional murder. And most prosecutors don't have to spend their career and prosecute the intentional murder of a child. I have. And it happened again 2 weeks ago in my jurisdiction. A beautiful little girl was beaten to death And when I leave here with you guys, I'm going to the medical examiner's office so she can educate me on just how many injuries she had. And she has 3 pages of notes on that. If we have a statute that calls the worst crimes in Kentucky the worst of the worst, the intentional murder of a child should be on that list. Everything, like Representative Wilson said, in the aggravating circumstances statute deals with what a defendant was doing. Was it in the course of a robbery, use of weapon, mass destruction, things of those nature. The only aggravating circumstance that has to do with who a victim is and who gets protection is you and me, public officials. So right now, under the state of the law, you and I have more protection and more bite under the crime bill than children. And every state that believes in capital punishment, which is also life without parole. I know 2 folks spoke out and spoke their heart about life without parole. That is a sentencing option, and as you can tell by the trends that Mr. Wilson pointed out, that's usually a default sentencing option for juries across the Commonwealth of Kentucky. I've tried a death penalty case. 4 innocent victims were brutally murdered. He got life without parole. So the death penalty is not something that is a pandemic or something that breaks out falsely in Kentucky, and all the exoneration statistics that are pointed out to you, exonerations here and there, those are national statistics, not Kentucky. I think Kentucky juries get it right, and they do an excellent job. I just think if they get the opportunity, and the last thing I'll say, and I'll be quiet, I know I was told to be brief. Michael Cody Huff got 45 years by plea. I offered him 50, which was the max. The mother consented to 45 years. He gets parole eligibility in 20 years. Every day I wake up and look in the mirror, I feel like I failed Kimber Collins. And I'm asking for the tools to remove people vile enough to intentionally murder a child from our society. Thank you.
Mr. Chairman, just one brief thing. No matter how much evidence we had, no matter what we could show a jury, we could not guarantee to Kimber's mother that this man would not get out of prison one day. If it was an aggravating circumstance, the jury would have that option. We would be able to tell her there is a possibility that he will never walk free again. Under the current state of the law, we cannot guarantee that for our children victims. Thank you.
We got a motion and a second on the bill. Madam Secretary, please call the roll.
Senator Berg.
Explain my no vote.
Yes, briefly.
I understand that the murder of a child is extremely traumatic, and none of us wants to allow that to happen, and certainly none of us wants the perpetrator to be free or to have a reduced sentence. But for me, 1, I don't believe in the death penalty. For 2, I believe that each and every individual has the same exact spark of God in them as everybody else. So why aren't we including those 89-year-old women who somebody comes into their home and violates them and kills them? Why aren't we including every other horrendous, heart-wrenching victim in this state? I vote no. Thank you.
Thank you, Senator.
Senator Carroll.
Aye.
Senator Deneen.
Aye.
Senator Neal. Senator Schickel.
I vote aye.
Senator Stivers. Senator Storm.
Aye.
Senator Turner. Senator Wheeler.
Aye.
Chairman Westerfield.
Aye. Bill passes with favorable expression, I believe 6-1. Thank you, Representative Wilson. Thank you, gentlemen.
Thank you very much. Thank you, Mr. Chairman. Thank you,
Yes,
ladies and
sir.
gentlemen.
Last bill to go is House Bill 262. And I'm going to ask Jenny, thank you, Ms. Oldham, come on up. And Lewis, if you're going to speak also, thank you. You all have the floor. And again, I apologize for cutting it short, and I want to make sure Mr. Lawson has an opportunity to speak on behalf of KACDL for 262 as well.
Thank you. Jenny Oldham. I'm the president of the County Attorneys Association and also the Hardin County Attorney. This bill does 3 things, and I'll be as brief as I possibly can. 1, currently the statute requires, in order for us to admit the BA into evidence in a trial of a DUI, would require the officer to testify that they had followed the manufacturer's instructions. There are no manufacturer's instructions. for the intoxilizer. The officer is actually trained according to his training, and that's the wording we're asking for. Secondly, currently there's a 4-hour wait before someone's released from jail on a DUI. This is increases that to 6 to prevent someone from getting in a car as they leave the jail, perhaps under the influence and harming someone.
Thank you, Mr. Chairman. My name is Louis Kelly. I'm the Commonwealth's attorney for the 54th Judicial Circuit, which is Boone and Gallatin counties. Section 3 of this bill would add a charge, a set part to Chapter 507, allowing for vehicular homicide, which would be if you cause the death while also driving under the influence under KRS Chapter 189A. What this basically does is it fills a gap. Right now, as prosecutors, if we have a death that results from a DUI, we can charge them with reckless homicide, a D. We can charge them with man second, which is a Class C felony, or we can charge them with wanton murder, which is a Class A felony. We do not have a Class B option. We like to have as many options as can because cases run the gamut, and we want to do what is appropriate.
Got a motion from Senator Schickel and a second from Senator Deneen on the bill. Sorry to cut you off there, Lewis.
Not
Yeah,
at all.
Senator Wheeler has a question.
Yeah, I mean, and I don't do a whole lot of criminal law. It's been years, but I mean, I did do a few DUI cases back when I practiced and defended, and there was a manual that you could cross-examine the officer with that kind of told you how to operate the machine, you know, how long they had to, like, you know, make sure their mouth's clean and or it doesn't have.
You are correct.
And so are you saying that you're not going to be able to use that now?
No, I'm saying the latest version, the Intoxilizer 5000EN, no longer has those. And those are the ones that are, and I'm talking about the Intoxilizer that's at the police station or the jail. So those former Intoxilizers had manufacturer's instructions. So they no longer produce those.
And which agency has now developed some protocol that this now points to?
Yes, Department of Criminal Justice training.
So DOCJT has created its own sort of manual, and now the statute points to that instead
Correct.
of the manufacturer's.
Okay, so did the manufacturer intentionally quit producing a manual?
They couldn't really answer that for us, but we have
Okay.
investigated that, and the answer is we don't publish instructions.
Okay, but there is I guess, a protocol through DOD.
Yes.
Okay.
Yes.
Yes.
All right, I'm comfortable then.
Yeah.
Thank you.
Seeing no other questions, I want to have Mr. Lawson come on up. Good morning.
Thank you, Chairman. All right. Philip Lawson on behalf of KCDL. The main issue that I have, I hope that you all have received and reviewed my email, so I won't go into those details. But one of the main issues that we have is what exactly in terms of causation this bill provides. If you look at the page 3 regarding the vehicular homicide bill, the language referenced in 1A references causes, and then in B references results. And as I stated in my email, there's two different types of causes that you see both in the civil world and then in the criminal world. We have cause and we have the mens rea element. To me, I think, and I detailed in the email, I think courts are going to struggle with interpreting what exactly the level of causation is needed for this particular crime. As you know, cause is an antecedent. It can be a 1% cause under criminal code. Under civil law, we have the proximate cause. Saw a question. Okay, fair enough. And so I think that the courts are going to struggle in terms of what the result means. And so what I was actually going to propose here, and I was going to propose by separate email, was actually an amendment that I think clears up the controversy. And this is actually straight from the Colorado statute regarding vehicular homicide. And I think it'll provide clarity in terms of causation for the courts. And it reads that if a person operates or drives a motor vehicle while under the influence of alcohol or one or more drugs, or a combination of both alcohol and one or more drugs, and such conduct is the proximate cause of the death of another, such person commits vehicular homicide. I worry that the term results, which is not defined in statute, which is not a common term under case law, that courts are going to struggle determining, is it a but-for cause that we're trying to criminalize here? Is it proximate cause? Is it something other than that? I think Colorado, follows what a lot of states do by still making it a strict liability, but being very clear on the causation component. In our law, the courts can readily go to that bank regarding the definition of causation with proximate cause. Been around since I think 73.
Do we use proximate cause in any other criminal statutes in Kentucky?
We do not. But a lot of these states, including New Jersey and Colorado, also use the proximate cause. The problem is with strict liability, Chairman, is it's different than all other criminal statutes. The reason is we have a actus reus component, and then we have the mental state. That's how we usually deal with causation in the criminal world. But here,
If I can play devil's advocate for a moment,
Sure.
doesn't this give the jury the latitude, the finder of fact, to determine whether or not result is really what happened in a certain case?
I don't disagree, but the thing is courts are going to struggle with determining what results is from a causation standpoint. I mean, what is it? I mean, is it the but-for cause? Well, if a court's going to look at that particular term, they're going to say, well, they used cause in the prior subsection. They must have meant something different. Was it something more than a but-for cause? Was it proximate cause? We don't know. They're going to go through a statutory interpretation exercise trying to determine what results is as it pertains to the issue of causation. That's why I think that even though, yes, we are going to I would propose going to a civil standard as it relates to proximate cause, it's a pretty consistent thing that other states do. Again, Colorado does it. New Jersey does it, using that proximate cause analysis. It keeps it strict. It's a strict liability standard, but it allows courts to go into that bank of law as it pertains to proximate cause to determine what exactly causation level means.
Okay.
So that's what I would propose. And we did mention that I think in terms of the level, the Class B, if it is charged as a Class B, it would be akin to a violent crime, similar to specific intent, manslaughter, first degree. We would propose a Class C akin to manslaughter, second degree. Of course, a lot of these other statutes, too, in other states, as it pertains to these strict liability statutes, it's much lower than what is proposed. For instance, Texas has a sentencing range of 2 to 20. Florida has a minimum of 4. This would propose a minimum 10 to be served at 85 because it would be a Class B felony and violent under 439. So that's the other thing we would ask that the committee consider in terms of potential sentence.
Thank you, Mr. Lawson. I appreciate it. Senator Schickel had a question.
I noticed when you sat down, sir, you identified yourself by an acronym of who you represent, which we all know who that is, but there are people that watch these proceedings on television.
Mm-hmm.
So would you tell us who you represent again?
Yeah, absolutely. Again, Philip Lawson on behalf of the Kentucky Association of Criminal Defense Lawyers.
Thank you.
It's the easiest question all day. All right. Any other question or comment? We got a motion and a second on the bill. Do you all, either of you, want to say anything else?
Not unless you have any questions, Mr. Chairman.
I don't see any, so we'll move along. Madam Secretary, please call the roll.
Senator Berg.
Explain my vote.
Yes, ma'am.
I vote aye. And I vote aye because I think this is really important. People are getting killed by intoxicated drivers. They need to be held responsible. And God forbid we release an intoxicated person from one of our facilities. Thank you.
Senator Carroll.
Aye.
Senator Deneen.
I vote aye. Explain my vote.
Yes, sir.
I want to thank the folks that have brought this forward and the addition of vehicular homicide to the statute. It is sorely needed, and we have many, many families that have lost loved ones due to intoxicated drivers beyond alcohol. So I appreciate the vehicular homicide statute. Thank you.
Senator Neal. Senator Schickel. Aye. Senator Stivers. Senator Storm.
Explain my no vote.
Yes, sir.
So although I do appreciate the bulk of what's in the bill, when individuals are contacting me and tell me about issues about the intoxilizer requirements, I've faced that in my practice. I've heard about it throughout the Commonwealth. It's a big issue, so I'm very favorable to that aspect of the bill. And I like how you all put that in there to make me want to vote for it, because I'm very inclined to vote for it because of that. But the other issues I see are I've tried these cases to juries, and they're very difficult. And I think it's important to focus on the intent, the mental state, the causation, and those issues that were raised today. The last bill we heard about intentional acts, intentional killing. To me, this is a bit ambiguous in Section 3, so therefore I vote no.
Senator Turner. Senator Wheeler.
Mr. Chairman, explain my aye vote.
Yes, sir.
Yeah, I mean, this is one of those bills that I'm kind of balancing. Do I like more of it than I don't? I mean, I do have some concerns that the Commonwealth would use a machine that refuses to publish an instruction manual. I mean, that does raise all kinds of questions in my mind, or when they did previously have one, then suddenly it goes off the market when people get questioned on that. But again, I overall, I think it's a good bill, so I am going to vote aye. But, you know, that is kind of an interesting situation.
Chairman Westerfield.
I vote aye. What's our count? I lost. The bill passes with favorable expression on a 6-1 vote. Thank you, Jenny and Lewis. Thank you. I appreciate you making the trip and covering that for Representative Flannery. Seeing no other business coming.
Mr. Chairman,
yeah.
I need to be recognized to change my aye vote to a no vote on House Bill 369, and that will not change the outcome.
So ordered. And so